I do not intend to read out the comparison, but the court will receive the necessary copies, and this is also in proof that the statements are identical.
You claim that these 34 paragraphs are identical. There is an identicity.
Identical, and again what I said, footprints.
When was it published?
This was published in Life. We have it here in T37, a statement by the accused.
All right, we'll find it, Mr. Hausner says, President of Court.
When the accused was already in Israel, in any case. He did not deny that the publication never came from his own mouth.
The 28th of November and the 5th of December. There is also a translation to German, I understand, Mr. Hausner, says Judge Halevi.
Prosecution, we translated into the German, and this was given to the accused, and he made his comments and explanations in T48, T49, T50. He does not deny the document, he only remarks here and there. All through the handwriting, the court will find all kinds of remarks, the explanations, remarks, comments, so that basically he does identify the document as originating or emanating from himself, identification of contents, as is the expression, because if court compares this with some of Sassen's statements, that he did in a certain way make all the statement more mellow to the benefit of the accused, but the things said are identical. Here too the court will find the way of the material was handled the same way as the Sassen document was handled. Remarks, corrections.
And therefore I say that so far as the testimony is concerned, and as it was said by Judge Heshin, there was a similar case, 1949. This was in the High Court judgment on page 25, paragraph 25, page 50, where a similar situation could be found.
Volume 7.
Yes, but as paragraph 9 deals with testimonies and statements of any kind,
no, not a confession. We have also fulfilled the necessity of proving a confession. We heard the accused's words, and this is our answer, which is complete. I wish to add one last thing. The counsel for the defense maintains that parts are missing. This is not the entire document, this is only part of a document. This matter must be examined in regard to the value, the probative value, but not as far as the question of admitting the document is concerned. The court will find it in Roscoe, Criminal Evidence, page 52.
What edition is it?
This is the 16th edition of the year 1952.
So in Gardner at Hancock's, the Court of Criminal Appeal thought that a jury should be warned to be cautious of the report of what only purported to be a portion of a conversation which the witness was not intended to hear.
In other words, if we submit this statement, then the court will warn itself. Maybe there were other parts which are to the benefit and may be useful to the accused, but that does not reflect from the admissibility of the document itself. We have proved the identity and the connection.
Before concluding, I should like to ask one question. The question had already been asked, but perhaps we should have it elucidated, namely the importance of handwritten corrections. There are about 70 pages of various corrections, of various additional marginal remarks. I should like to ask the question without knowing what is written there. I should like to ask a rather abstract or legal question. What is how is the question of the importance of corrections connected with the admissibility of the document? We should like to have some elucidation on this point.
I shall only describe the corrections and not bring them verbally and prove how they are intertwined.
I believe that in these documents where remarks are made by the accused to the live, there is also a statement of the accused that there was a transcription and tape recording. There is no statement that a particular document presents a correct transcription, but it's clearly stated that the talk took place, and furthermore that this conversation was recorded. And it is further claimed that all throughout the transcription of the recording there are mistakes, and also when the translation is made into English, and furthermore from English into Hebrew, there might be some more mistakes. In any way, the statement is made to the effect that the conversation had been transcribed. Now, transcription is a mechanical process which, unless forged and falsified, it contains only the true conversation. Of course, there is always a possibility that someone distorts it, but so far as transcription of the recorded text is concerned, there is very little possibility of falsification, because what is recorded is exactly what had been recorded by the two persons participating in the conversation.
Except the typist's errors.
And this brings me to the question of the importance of corrections. If somebody knows that his conversation had been transferred, and that later on it is transcribed, and then when the transcription is submitted to him, then two remarks are possible. A, corrections in such a way, that means to say, saying that this word is distorted, or this had not appeared correctly, and then it is necessary, of course, to compare the recorded text with what has been written. But there is furthermore a possibility of certain supplementary remarks. That means to say essential corrections. But these are not the corrections which are important for us. We might waive them. here. These corrections want simply to convey the idea that I express myself for the first time in an incomplete manner, and on this occasion I should like to express my ideas in a more complete way. This does not mean to say that what had been said before was not correct. Simply the person whose conversation had been transcribed might simply point out that he wants to elucidate his previous statement by either an additional or a corrected statement. But that doesn't mean to say that this statement before was not correct. Therefore, it will be necessary to examine what the corrections were and what the situation really looked like.
If I am permitted, I shall try to give the court the necessary information. The material is actually in two parts. There are transcriptions of 67 tapes in 16 files, and then handwritten material in file number 17. We do not have the tapes 6 to 10, and page 3 is missing in tape number 41. Tape number 52 is wrongly numbered as 51. The larger part of the tapes contain handwritten corrections, also typewritten corrections, or references by numbers to corrections on special sheets. In 15 out of 62 tapes, there are no corrections. The corrections appear in two different ways, and there is no way or no criterion showing the difference between the two forms of corrections. There are corrections on the transcription itself without numbers, and sometimes there is a number in the transcription and corrections on separate sheets. In tapes 11-12, corrections are marked in the transcriptions themselves. The number of corrections in the transcription, the errors, are a few hundred.
Present, of course, several hundred corrections of misprints.
The number of errors which were made on separate sheets are 204. We have 54 such corrections. Now, the character of those corrections, only a few are qualitative regarding to the contents, and these are at the end of the tapes in the handwriting of the accused. For instance, in tape 52 and 53, all other corrections, almost all of them, are printing mistakes and errors, corrected especially in a very in this page of remarks or in the transcription itself. The corrected tapes and the tapes which were not corrected are not concentrated. There is no a certain part of the statement not corrected or a certain part of the statement corrected. They are all over the document. The recording is in the form of a conversation. This is carried on during 4 months, this dialogue, and The intention, as is said there, is to publish a book on Eichmann's duty and task in the persecution of the Jews. The aim of the book is written out in the first 3 pages of the first tape. In the 30th tape, there is a remark number 43 saying, please do not include this in the book. And on the last page of all the tapes, there is a remark by Eichmann that maybe these conclusions should not be printed whilst he is alive. Moreover, on page 357 in tape number 41, Eichmann speaks in regard to what he said in 41 tapes. On page 360, there is a conversation on the same evening, early. There were also discussions between the two, especially in tape 36, 47 and 54. And all in connection with the initiative to exterminate the Jews. And when Eichmann objected to the way Sassen interrogated him, Sassen replies that he is writing a book which must put to naught the arguments by Eichmann's people who objected to Eichmann. There is special value to the extra blätter, the extra pages, which are found at the end of all the recording, the end of the tapes. And these are a kind of jottings in regard to clarifying certain subjects which remained as an enigma up to the end. The statistics which was smuggled into the Wannsee report. The date of the order to cease extermination. The date of in connection with the large gas chambers. A date of the large action in Sosnovich in August 43, where it must be proved that there were no means of transportation.
Judge of Court, I don't know what my colleague thinks, but I believe we are now getting a little too...
Mr. Hausner, this was in reply to Judge Halevi's question.
Judge Halevi, in any event, these are additions, aren't they?
Mr. Hausner, the extra blätter, the extra pages will be discussed by me later. But in the dialogue itself, Eichmann is being presented with a document and his comments are requested. The Schupor documents, which we met during the days of the sessions of this trial. There are also documents, a document at least, which Sassen showed the accused, and we do not know of this document. But there are many documents shown to the accused, and these same documents were shown to him by Bureau 06. He was asked to comment on the same documents by Sassen and by Bureau 06.
Judge Rave, Mr. Hausner, may I ask one question? These additions in handwriting, can one attach to these additions definite sections in the reprint? Can there be such an exact juxtaposition? I'm not sure whether I expressed myself clearly. so that can one arrange it so that these additions in handwriting plus the original sections in the reprint form some kind of a unity of its own, a document of its own with its own independent meaning.
This is the material in our file 17, entirely in handwriting. There are the following parts: 8 pages of corrections to tapes, remarks. Pages 6 and 7 are in regard to the subject itself. 2 pages of additional material on the same subject. Then, later, some tens of pages which contain a detailed statement in the accused's handwriting on the subject, my conclusions in regard to the Jewish problem and socialist rule for the years 33 to 45. Does this answer your question, Your Honor?
Judge Rave, this is difficult to say. One has to know the material for that. Therefore, I do not know whether I have a clear picture.
In any case, the first answer is that 8 pages in handwriting contain the numbered remarks, corrections.
Judge Rave, and to this one can add exactly the proper and appropriate sections in the reprint?
Of course, the way it was done was putting numbers in the transcriptions and then separate pages for the remarks in accordance with the numbers on the transcriptions. We have only 54 of these corrections, where there are 204 in the statement itself. On the other hand, in the transcription itself,
Judge Rave, and these additions with the numbers cannot be understood without the appropriate references in the reprint? Is that so? They cannot be understood alone?
Of course not. Of course, they make sense only in connection with the transcription. But besides this, the remarks which Superintendent Hagag discusses are in the transcription, not in file 17. They are spread all over the document.
Judge Rave, and this is something which one could call something independent, not necessarily connected with the other parts of the reprint.
No, I shall show to court from a distance to what I refer.
Judge Rave, I understand. I'm merely speaking about the handwritten part.
Here, I have page 2 of tape 36. Here are corrections in the accused's handwriting.
President of Court, just like in T37.
Exactly, Your Honor, as in T37.
Judge Rave, no, I meant the later part.
Yes, the printed part. I maintain that as far as the graphological identification is concerned, the identification of the contents, the adoption of the document and handling, there is enough evidence to receive the document, although the probative value which the court will give to this document, and this after the court reads the contents and the accused testifies.
President of Court, when did this document get to the prosecution, Mr. Hausner?
Your Honor, this is a bit difficult to say. I cannot say. Because,
President of Court, difficult to say?
What does the court mean by saying prosecution? If the question is when this came to my hand, then only 3 weeks ago.
Judge Rave, but it got to Israel a little earlier?
I beg the court not to press in regard to this question.
President of Court, well, you're not obliged to reply, of course, sir. I would like to make one personal remark, also in connection with the accuracy of a reprint and a transcript. When this question first arose, this, I believe, was in our session number 16. My colleague, Judge Halevi, brought up the question.
This concerns material which, when recorded and discovered, was confidential and known only to the accused and a very small number of other persons. He was interested in his explanation.
President of Court, Mr. Hausner, this is really a new argument, isn't it?
Mr. Hausner, this in reply to the counsel of the defense.
President of Court, of course, everything is a reply to the other side, but here we see, here Dr. Savatius will again have the right of reply and so on.
This is at the, I will abide by the court's directions.
President of Court, now we are getting it from both sides.
Herr Präsident, ich will nur wenige Worte sagen. Dass der Angeklagte auf Band gesprochen hat und dass diese Dinge vorgetragen hat, die ja auch hier der Anklagebehörde aus freien Stücken erzählt hatte, die doch recht unangenehmer Natur sind, mal vorsichtig zu sagen. Das wird ja nicht bestritten. Okay. Aber es wird ja behauptet, es ist eine Verdrehung. An diesen Stücken sollte die Story aufgebaut werden und wurde sie aufgebaut. Und daher dieser spätere Vertrag, nur das, was jede Seite mit dem vollen Namen unterzeichnet.
Mr. Savatius, only a few words, Your Honor. The fact that the accused recorded something on a tape, as he did here in Bureau 06 of his own will, this is not in dispute. Here, certainly, he said a number of things which, to put it carefully, were embarrassing. There's no dispute about this. The dispute is only about the selection, about the composition of this journalistic story.
President of Court, we shall consider the matter and give a decision. Can we sit for another hour now? And you have one more witness. Mr. Hausner, I beg a direction by the court in regard to a certain chapter which was not clarified before the court, and since the court has remarked in connection with other matters, I do not wish to call the witness before receiving a direction by the court.
President of Court, yes, what is the question?
Mr. Hausner, I overlook and disregard many requests by people who wish to come to this court as witnesses.
President of Court, you are not the only one, sir. I receive these applications just as well, and the court is not the proper address for them, of course.
Mr. Hausner, I receive hundreds of applications, but we can only use the searchlight means and call the attention of the court to pictures and scenes which are to decide this case, and to request the court also to draw conclusions in regard to other happenings. But there is one side of the whole trial which was not described to the court yet, and this is the escape of the Jews when the camps were liquidated to the forest. They're organizing into underground movements. They're fleeing from the persecutors, their hardship in the woods, the Germans running after them into the woods, into the forests, the diseases and epidemics, the protection given to them by the partisans, and their forming partisan units. According to the information I have, there were some 20,000 Jews in such units, and as well as partisans. I know that the court does not approve of the fact and our attempt to describe a picture to the court. The court wishes to summarize and to stick to the indictment against the accused. But there's two concerns the accused. They were running of persecutions and hardships which the accused brought upon them. They were forced to hide, and what they experienced by the hands of the accused, if not directly, then indirectly. The testimony will be short from one of the men who saw the camps.
President of Court, one of the partisan camps,
one of the people who escaped into the woods after the uprising in Ghetto Vishnitz, he saw the family camps, he joined the partisans, and for 2 months was on the run. The Jewish families hiding in the woods, the happenings and the experiences of those families. Then I wish to put a number of questions to Shalom Polevsky of Ein HaShofet. This will not take more than 20 to 30 minutes. I request the court to enable me to complete the picture.
President of Court, what else does the prosecution have?
Then I have a number of documents in regard to Action Reinhardt, and then the testimony by the advocate Hoter-Yishai, who whilst in the brigade met the camps and inmates.
President of Court, first of all, Dr. Savatius, what do you wish to say about this application now concerning a description of the partisan life?
Herr Präsident, ich bitte doch, es auf die Erheblichkeit zu prüfen und ob es nicht kumulativ ist. Ich habe darauf verzichtet, in all diesen Fällen einen besonderen Einwand bezüglich der Unerheblichkeit zu erheben, weil es ja doch für den Hintergrund von großer Bedeutung ist. Aber ich glaube, es geht jetzt zu weit. Ich habe selbst bekomme auch Angebote von Zeugen aller Art, auch von jüdischen Zeugen, die auch in irgendeiner Form eine Aussage machen wollen. Ich habe sie alle sehr genau darauf geprüft, ob sie irgendwelchen Beweiswert zum Schutze des Angeklagten haben, und habe das alles zurückgestellt. Ich wäre dem Gericht dankbar, wenn auch hier eine Beschränkung eintreten würde.
Dr. Savatius, Your Honor, I would like to, Your Honors, to discuss this request and consider whether it is not inadmissible and whether this would not be cumulative evidence. Hitherto, I have foregone my right of objection very often to questions of irrelevant evidence because sometimes the matters are important for the background. But this, it seems to me, is going too far. I, too, have received many applications for evidence, including applications from Jews who propose to come and testify and illuminate this or that aspect of the defense. I have examined everything very carefully, whether it could serve for the defense of the accused, but I have then rejected all these applications hitherto. I should therefore be grateful to the court if it were to reject this application now.
President of Court, we shall give a decision in this matter too during the recess, but let us complete the question of documents. Will this
went out for this task without much regard to the formal framework.
What did you find in those camps? What did you see yourself with your own eyes?
I believe that if I try to exhaust in a few sentences what I saw, I would say that we found a horde of living people who, from a psychological point of view, was no longer much different from those bodies, the dead bodies, whom we found with amputated limbs and even amputated heads, decapitated bodies. From a bodily point of view, everything was done, especially in the first period, to restore them to their feet. To the extent that this was possible, I think, unless I'm wrong, in Bergen-Belsen 52,000 people were found, and 27,000 of them died in the course of medical treatment. Yes, 27,000 people died after liberation in the course of this medical treatment, which was administered in an attempt to restore, to revive a spark of life in them.
What did they die of?
If their weight was 30-odd kilograms, they had no contact with life anymore. They had no strength, no will to survive left in them, no resistance. They looked like, if I can make a comparison to any war horrors, like forests where only amputated trunks remained standing. Thus, each and every one was with amputated limbs. I mean symbolically. His children were taken, his wife was taken. All that remained was an amputated trunk, a severed trunk, bleeding and wounding, and these wounds were only reopened really after the liberation and were bleeding. He could not forget this, and his internal life hardly made it possible for him to find any contact with others.
Could you describe your first encounter with the inmates where you were?
The first meeting took place in one of the camps. I believe it was the first camp I visited, a refugee camp. Maybe as an example, I should say a few words for clarification. All over Europe, Europe was dotted with these camps, which included about 8 million of these DPs, displaced persons. They had about 10 to 12 categories of these people. All of them were defined in one document, which was called the Administrative Memorandum number 39 of July 1944, and that stated what the ways of treatment should be for all of those found in the camps in Germany. Among those 8 million, there were people of all nations and of all types, and the Allied armies saw it as their primary task to restore these people as quickly as possible to their homes. At days and nights, swarms, convoys of these people moved in all means of transport, trains, planes, on foot, in bullock carts, whatever they could find. From the occupied territories, they streamed homewards. Of course, in those camps, we were looking for the Jews. The truck would remain in the huge area of the camp, many square kilometers. We had a little pennant the size of a palm, and when I had a few moments left to go to the office of the camp to ask for any Jewish survivors, I would find the truck surrounded with a multitude, which to this day I find it difficult to forget. One could call these people human beings. They looked like creatures, but they were not human beings. At first I thought maybe there was some kind of a fight between these soldiers who were guarding the truck and the multitude.
What camp was it, asked the President of Court?
It was the first camp in Freimannplatz Kaserne, Freimannplatz Garrison. When I approached, I saw that these hundreds of people were fighting among themselves with a few ounces of strength left in order to get as close as possible to the soldier who was in the middle and to touch with their hands the Jewish Star of David, which was the insignia of the Jewish fighting brigade. And of course, these 4 soldiers could not come in contact with all these hundreds of people who surrounded them. And there were among the soldiers among the refugees who kissed the Star of David that was that was painted on the military truck. And those who could not come approach either the soldier or the truck crawled on the ground and embraced the feet of the soldiers and kissed their boots. President of Court, I hereby open the 74th session. The Court gives a ruling number 79. We decide by a majority vote to admit in evidence from this document called by the Attorney General the Sassen Document only what is called by Superintendent Hagag in his expert opinion, file number 17, that is to say, photocopies of matters which were written in the accused's own handwriting, to the extent that file 17 contains remarks and what purports to be the reprint of recordings made from statements of the accused. We shall admit also those parts of the reprint to which these remarks refer, in as far as these parts are needed to understand the remarks. We accept the expert testimony of Superintendent Hagag for the authentication of the handwriting of the accused after the defense counsel did not voice any objection to that expert opinion. The expert opinion will be marked Exhibit T1392. We reject the application of the Attorney General in all other parts accepting what was said above. Judge Halevi dissents from this limitation and believes that one should admit in evidence the Sassen document in its entirety, accepting the reprint of those tapes about which there are no corrections or other remarks in the handwriting of the accused. The reasoning for this ruling will be given at a later date. President of Court, we imagine that as a result of this ruling, you will be able to submit file number 17 immediately, and then you will have to do special work in order to extract from the reprint those passages which have references in file 17.
I cannot now say which parts we can hand in or those relating to the remarks in file 17. This cannot be done today, Your Honor.
Yes, President of Court. Yes, I realize you cannot do it today, but please, you could possibly submit file 17 now.
File number 17 is here, separate. We also have a reprint because this was deciphered and typed out.
President of Court, very well, you can submit that, and you will also have your own copies. It is in 3 envelopes. Mr. Hausner.
Yes. You have a reprint. Will you please bring it to court? This Mr. Hausner to one of his colleagues.
You have two copies of the photostatic reprint?
3 copies.
Of the photostat itself?
There should be 3 copies of the photostatic copy. There should be another one copy. We prepared, the parcels are a little larger. They contain more files than number 17, but we shall now submit to court only file 17 in the necessary number of copies.
President of Court, we shall call your file number 17, Exhibit T1393. This number is not certain.
By permission of court, since I cannot now submit the other passages, I request to be granted time and do so later. Shall request the court to call attention to a certain number of quotations out of those which are accepted by court, but not now, because I might also quote passages which were not admitted by court. Since Superintendent Hagag is here in court, may I call him to the witness stand to verify the undeciphered passages of the Mufti diary? He has something to say to court.
President of Court, well, since he has something to say to court, we shall call him. How were these documents marked at the time?
I understand Superintendent Hagag has them in his hands, and
yes, but we have marked them. We should like to know the exhibit numbers.
Mr. Bodenheimer enabled Mr. Hagag to study the documents.
President of Court, Mr. Hagag, would you please take the
I swear
oath?
by God to tell the truth, the whole truth, and nothing but the truth.
What is your first name, Superintendent?
Avraham Hagag.
Mr. Hausner, you are an officer in the Division of Criminal Identification and Police Headquarters?
Yes, Your Honors.
And you speak Arabic perfectly and know the language perfectly?
Yes, Your Honors.
And you have in your hands a number of documents which are exhibits of this court. Would you be so kind as to tell us what you can read in the Arabic writing in these exhibits? Would you be so kind to identify each exhibit which you make reference by number? President of Court, is Arabic your native tongue, Mr. Hagag?
Yes, Your Honor. Your Honors, amongst the documents, I have the one marked 1267, Exhibit 1267.
Dokumentennummer auch anzugeben, weil ich die TAF-Nummer nicht habe.
Dr. Savatius, may I request that the original number of each document be also mentioned, since I do not have the exhibit numbers.
1307. Your Honors, this document is a photostatic copy of 2 lines in an agenda, a diary, 1944. The year on this diary is 1944. In the 2 pages, there are names in Latin characters, and near each name there is a remark in the Arabic. In the part dated the 9th of November, a Thursday, it is written in Latin characters the name Eichmann, and at the top above this name two lines in Arabic. I have deciphered the Arabic writing after comparison with pictures of qualities of his handwriting and the picture of his handwriting of Haj Amin al-Husseini. And according to the specialties of his handwriting, this can be deciphered to read as follows. I have enlarged the writing in order to show the court.
President of Court, would you like to come closer to the bench?
No, Your Honor, I rely on your judgment.
President of Court, whoever wishes to approach the bench, please do so. Remark Dr. Savatius approaching the bench. And Superintendent Hagag.
The first word is Faruza. Faruza.
نادرة جدا. الترجمة هو يهلم نادر مئات.
نادرة جدا is very rare.
مغيث للعرب. והמציל הטוב ביותר לערבים.
And the best factor for the Arabs, that is, will save the Arabs. Below, one can read Dagobert von Mukush, Buchberg, once in the Latin characters, once in Arabic, 11th of November, 70 years, it says, and then a note to send greetings to him. At the top, Mayor Ostenhof, the Imperial Hotel.
President of Court, this means with reference to the subject? What is Dirna?
Dirna, there is a town in Libya called Dirna.
Kamilan, Ken?
And Kamilan? Akmal, what is that?
That is in its entirety.
Couldn't that be Farouk, the first word?
I compared each character with the Mufti's handwriting. there is a very special quality in his handwriting that the vowels are not in order. He sometimes leaves them out. Then another special quality that he joins together letters which usually are not to be joined together in the Arabic.
President of Court, yes, like in the word nadira here.
This is a character, a letter which should not be joined with the letter before it, but the Mufti did usually join such letters. And this is the explanation by the expert
Couldn't be Farouk.
that it could not mean Farouk, the first word in this document.
President of Court, Faruza, then? What would that be?
Faruza is a precious stone. Even Nedira, a very rare stone. And there are two dots, which could be the Arabic character M, or there are two other possibilities, but the one acceptable and most reasonable would be the word Faruza, which means a precious stone, a precious gem, Faruza. And because of this way of joining letters which usually are not joined, and because the Mufti used to leave
President
out
of Court,
vowels,
President of Court, now this is missing. What would this be, do you think?
this may be blurred.
President of Court, but it looks like a word.
This is like
President of Court, no, this is not nun, it's a few letters together.
no, this may be
Is this the,
an N, an Arabic N.
is this the punctuation of Nurisa?
The Mufti did not put in all the punctuation usually. This also explains.
President of Court, yes, like in the Quran writing.
Certain marks like in the Quran are put
President of
into
Court.
the writing.
President of Court, is this also acceptable in general writing, not only in the Quran? Could you just tell us, please, Mr. Hagag, what was your comparative material? Mr. Hagag, please stay near the bench for a moment. This is from the same diary.
Yes, from the same diary, and also please, these are the samples. Here, this marking, the Hamza in the Arabic, does not refer to the word at the top.
President of Court, Khatab.
This is only an ornament to the Arabic handwriting, and these can be found.
President of Court. And here, this is from the left column of T1278. 1268. All right, we shall content ourselves with this example, Mr. Hagag, and please keep this document with us. Please leave it with us. Now, the comparison is T1394. The enlargement from the diary would be T1394.
Now, Mr. Hagag, so that we all understand, what are the words in the Arabic which appear above the Latin word Eichmann? Your Honors, according to the deciphering and bringing into account the special qualities and specialities of Haj Amin's handwriting, I deciphered these two letters, Farouza Nadira Jiddan wa Khayra Muis al-Arab. This is a rare gem and the best savior of the Arabs. The Attorney General repeats, this is a rare gem, a savior of the Arabs, and then the word Eichmann in the Latin characters.
President of Court, is this a customary Arabic style?
This is a good Arabic, Nahawi. Haj Amin always wrote slogans.
President of Court, is the grammatical declension correct?
Yes, we all remember, for instance, the Haj Amin's motto. The sword spoke and the pen was silent. We remember that he always had such slogans and ideas and ways of expression.